another edition of South Texas Crossfire. This is Attorney Joe Flores reminding you to join us each and every week right here on KTMB with the Lopez family. My condolences to the Lopez family, and we dedicate this show and all future shows to Don Humberto Lozano Lopez and the Lopez family for making this happen. He is not forgotten, and he is honored on this show. I also would like to thank my good friend Carlos Lopez. You guessed it, the Ted Turner of South Texas Broadcasting, my good friend. With me today, I have the very distinct pleasure and honor of presenting Judge Robert Vargas of Nueces County Court at Law, number 1. Welcome, Judge. How are you?
Joe, thank you.
Well, I appreciate you coming on. You know, I had asked you to come on. I know how busy you are, and we rarely have the opportunity to get a judge on to talk about such an important issue. I think it was triggered also by the passing away of Humberto Lozano Lopez, our patriarch of our station, and the importance. He had a will, he had a power of attorney, and in our culture, and of course we address, and I'm addressing these remarks to everybody out there, Hispanic, black, white, Asian, whatever, Afghani, what have you, but having a will and having the estate planning. But first I want to introduce everybody to you. A lot of people already know you, but you are the judge of County Court at Law, number 1. And what kind of cases are handled there?
Well, it's a, as you said, it is a county court, which means it was statutorily created, and we have the jurisdiction that whatever the statute gave us. In Nueces County in particular, my court deals with criminal cases, but on a misdemeanor level. We also have civil jurisdiction, but only insofar as lawsuits are concerned, civil lawsuits, yes, not family law. And we have concurrent jurisdiction with the district court. So whatever a district court can try, we can too. And we're finding that we're getting a lot of civil cases filed in our courts. We also have the topic that we're going to be talking about, probate jurisdiction, which includes a mental health jurisdiction for those people that are suffering mentally and need some treatment. So that's generally the areas that I have practiced in.
Well, and you know, it's so important, the topic that we're going to discuss. And you brought up another wrinkle in it, which is the commitment hearings, which I've been privileged to participate in at Memorial Medical Center here locally, or Spawn Memorial now. In the basement, generally, they have the hearings.
Yes, right.
But, you know, so we know what kind of cases are seen in your court. As far as your background and training, you were in private practice before you ran for. How long have you been on the bench?
I took office in January 1st, 1987. So that's 25 years. And my background has been, I was in private practice. I was a legal aid attorney also. I think that's where I started, in Robstown. But I worked in the county attorney's office, and I was their chief of the criminal section under Carlos Valdez at the time.
Yes, Carlos, yes.
So.
And so you grew up in Robstown, Texas, cotton picker?
Yes, I did.
All right.
And I'm real proud that they went to the state.
Oh, yeah, very proud. Yeah, my dad taught out there actually for 25 years. He started teaching at Salazar.
Oh, really?
And San Pedro, yeah.
Yes.
He passed on in 2005. He had a will as well, thank goodness, and an advance directive, let me tell you. So
Very
let's jump
important.
in. Oh, yeah, so let's jump into it. Why is it important? You know, a lot of people say that if they sign a will, it's just like hospice service. You know, people say, I'm giving up. If I sign a will, it kind of reminds me of my mortality. You mentioned that before we started. And do you see that a lot in your court where people died without a will?
Yes, and as a consequence, it's a very expensive procedure to then deal with the estate and to deal with whatever property and the distribution that has to be made. It's always better to have a will, and the will, of course, is just a legal document that directs others how to deal in the disposition of a person's property. And what we do as a court is we sanctify it, and we give that person who's been named as the executor or the personal representative, we sanctify his powers. And Texas is not unique, but has a very simplified process in which if we call them independent executors and we empower the individual to act without court supervision. And that's very important, Joe, because having to come into court to ask for permission to do this or to do that is time-consuming and encumbering. So it's always better to give an individual power to take care of matters.
Well, and let's walk through a little step by step. Somebody, let's say if they were fortunate enough, somebody made a will, and you know, from the lawyer perspective, I tell people there are even will clinics that you work legal aid, and I volunteer my time pro bono. Often we can direct them to clinics where they set up a will. And some of these forms, even though I don't recommend it strongly without having at least an attorney review it, you can do your own will, like on these legal Zoom things now, but you need witnesses. There are certain issues that under the probate code you need to follow. But having a will, or holographic, write it on your own.
Right, right.
You know, so you see those, and generally it's a lot, it's 10 cents on the dollar or more savings just by making a will, opposed to it being admitted to probate. So we have somebody who passes away. They have a will. What happens next?
First of all, if you're the testator or the person who wrote the will, you've got to make sure that they can find a will.
There you go.
Okay.
Let's start with the basics.
Start with the basics, because that creates a lot of problems. You don't know how many times people have come in with copies that they went and found in the lawyer's office, and by chance the lawyer was still around and had a copy. Not all lawyers keep copies of the wills, and they were able to probate a copy, but many times people make a will and then forget to tell people where they left it.
Oh, wow.
And they get lost. So if you make a will, you really should tell somebody where they're going to find it. It's probably best if along with the will you write a letter of instructions. And I've seen this happen in my court, Joe, where especially with second families, the individual dies and the second family or the second spouse does the obituary from their point of view and how they saw it, and the first family's upset because.
Oh wow! I didn't even think about that.
Yeah, so you know, if people, it's hard to think about our mortality. People don't want to think about dying, and it's not the topic that people want to talk about or even think about. And so, but that elephant is in the room, as they call it, the white elephant, and it's not going to go away. Right? If there's anything for sure, we're all going to die. It's always best to die prepared. So it would be best if you left instructions as to what you want your obituary to say. Tell people where you were born. I know in my case, when my mother recently died,
very sorry for
we had made some preparations, but she had a safety deposit box, but she forgot to tell me where to find it, the key. So the only reason I knew about it is because I got a letter from the bank. So then I had to go and get permission to get into the safety deposit box. So these are all arrangements that a person should make beforehand, and probably do it with a letter of instructions telling people where their accounts are, where the keys are, where the will is, the deeds, the insurance policies. Did you have an insurance policy? Somebody's got to know about it. It doesn't help. Insurance companies, it's not going to know that you died unless somebody tells them. And I'm sure they're not voluntarily wanting to pay the proceeds from the insurance until somebody gets that information to them and proves that there was a death. So these are all important papers that people should consider along with making a will. The big problem that I've seen in my court is because there was no will, there were 5 children. I'll give you a scenario. Everybody was in agreement that a sister was to keep the house because she stayed taking care of mom at the house, you know, and the rest of the siblings were in agreement. But it was an oral agreement. In the meantime, it just happens that before mom dies, 2 of the siblings die, and they all had 5 kids. But they forgot to tell those kids that they were in agreement to give the house to their aunt or to the sister of the siblings. So now we have a person without a will, a house that may be worth $50,000, $60,000, and about 20 people having an interest in it.
It's just amazing the complexity of it. You know, a lot of people say, well, if I don't have a will, how complicated can it get? And we're just scratching the surface right now in this first half. We've got about a minute left before we go to break, but you know, before we go to break, the general picture, before we get into the specific voir dire, Your Honor, as we like to talk about, what would you like to tell them, the people out there that are watching? I mean, you've given them a lot of information, but what's the general idea about a will, estate planning, that you'd like to give them before a break?
Well, I think that they shouldn't be afraid to deal with it. A lot of times people are afraid that they're going to offend or upset their children or family members by talking about that and deciding beforehand how they'd like things to go. But if they don't, the state of Texas already has an estate plan ready. Either you use your plan or the state of Texas will give you one. And it may not be the one that you wanted. So I think people have to deal with that. And along with, like I said, along with a will, directing somebody how they'd like, and be specific. Be specific. If you want the clock, the grandfather clock to go to somebody, or the wedding band to go to somebody else, just tell them. Don't just say my jewelry, because that could be anything. You know, don't generalize. Be specific. Have a power of attorney, especially as you well know that people are living a lot longer, and sometimes, I know it happened in my case, my mother lived to the ripe old age of 94, but at her last year, her mind wasn't totally there, so Alzheimer comes in, and somebody's got to make those calls, those medical calls. So you should have a medical power of attorney beforehand, a financial power of attorney, and the one that people don't want to, and that people suffer the most with, is the living will or the medical directive about how much do you want to be kept alive artificially.
Well, I mean, these are very good points. When we come back, ladies and gentlemen, you're listening and watching Judge Robert Vargas, Nueces County Court at Law, #1. We're talking about the importance of making a will, and now we're also talking about an advance directive, statutory power of attorney, durable power of attorney, all these legal terms that come down to one thing is be specific, let people know what your wishes are, and as the judge said, don't be afraid to put it in writing and consult the attorney of your choice. Remember, this show does not constitute legal advice. Please contact the state bar or the attorney of your choice if you want to look at estate planning. And some people say they can't afford it. You know, there are ways to get help. So we're going to take a break, but first we'd like to acknowledge our sponsors, River City Hospice, 882-5900. That's 882-5900. Hope, dignity, and love. It's got to be River City Hospice. And Vasquez Flores Home Health, for your loved one out there who may need just a little help to maintain their independence and stay out of a long-term facility, contact Vasquez Flores Home Health. Backed by over 20 years of experience, Priscilla Vasquez can help as a registered nurse to find you a provider or someone to help you around the house and maintain your autonomy. We're going to take a break, and when we come back, you are listening and watching Judge Robert Vargas, Nueces County Court at Law #1, talking about the importance of addressing your probate issues when we come back.